Welcome to EU Privacy for All, Session 72 on GDPR, Article 88 to 91, Final Provisions. European Parliament suggested the addition of Article 89 on relationship to and amendment of Directive 2002/58. It was not let down as worded by European Parliament, but the proposal was retained. Also, Article 89A on European Parliament side was framing relationship to an amendment of Regulation 45/2001. On EU Council side, relationship to previously concluded agreements. That was finally retained. In final provisions, Article 88 lent the fact that the directive will be repealed when the GDPR comes into force. At the same time, references to Working Party 29 shall be construed as references to the European Data Protection Board. In Article 89 on relationship to Directive 2002/58 on e-commerce, the regulation shall not impose additional obligations. Article 89b on relationship to previously concluded agreements make clear that international agreements involving the transfer of personal data to third countries or international organizations shall remain in force until amended, replaced, or revoked. Article 90 on the evaluation of GDPR makes also real clear that the Commission will submit reports on the evaluation and review of this regulation to both the European Parliament and the Council at regular intervals. In this context, the Commission will examine, in particular, transfer to third countries or international organizations and cooperation and consistency mechanism. For those purposes, the Commission may request information from Member States and supervisory authorities, but also carrying out evaluations and review, taking into account the positions and findings of European Parliament, Council, and any relevant body or source. The first report that will be handed over is to be submitted no later than 4 years after the entry into force of GDPR, and then additional reports shall be submitted every 4 years thereafter. The Commission, if necessary, will have to submit appropriate proposals for the review and amending the regulation. Article 90A on the review of other EU data protection instruments lays down that the Commission shall, if appropriate, submit legislative proposals with a view to amending other EU legal instruments on the protection of personal data. Finally, Article 91 on the entry into force and application of the GDPR makes pretty clear that the regulation shall enter into force on the 20th day following that of its publication and apply 2 years from this date. Key provisions in the GDPR are also provided in recital 133 and 34. In the first recital, it is stressed that since the objectives of this regulation, namely to ensure an equivalent level of protection of individuals and the free flow of data throughout the Union, this objective will be better achieved at Union level in accordance with the principle of subsidiarity. In accordance with the principle of proportionality, the regulation does not go beyond what is necessary in order to achieve that objective. Recital 134 is of particular interest for controllers and processors. Beyond stating that the directive will be repealed with the regulation, it makes really clear that the processing already underway should be brought into conformity with the regulation within the period of 2 years. Concretely, where processing is based on consent, pursuant to the directive, it will not be necessary for the data subject to give his or her consent again, under the condition that this consent is given in line with the conditions required by the GDPR. Commission decisions adopted and authorization by DPAs will remain into force until amended, replaced, or repealed. The directive laid down in 3 articles the final provisions for its implementation. In Article 32, it was made clear that Member States will bring into force the laws, regulation, and administrative provisions within a period of 3 years, and will communicate to the Commission the text of the provisions of domestic law which they adopt in the field covered by the directive. In Article 33, the Commission was having the duty to report to the Council and European Parliament at regular intervals, starting no later than 3 years after the entry into force of the directive, make those reports public, and examine in particular the application of the directive to data processing of sound and image relating to natural persons, and submit any appropriate proposal which prove to be necessary. What should accountable data controllers and processors get prepared for? First, knowing that the directive will be repealed 2 years after the 20th day following that of the publication in the official journal of the European Union of the GDPR. Knowing that national laws should be brought into conformity with the regulation within a period of 2 years. References to Article 29 Working Party, the Working Party 29, on the protection of individuals, will be construed as references to the EDPB, European Data Protection Board. The GDPR shall not impose additional obligations regarding the directive on e-commerce. International agreements involving the transfer of personal data to third countries or international organizations, but also Commission decisions and DPA's authorization, shall remain into force until amended, replaced, or revoked. The Commission will have to submit reports on the evaluation and review of the GDPR to European Parliament and Council, notably on transfers and consistency, within 4 years after its publication and entry into force, and each 4 years. Finally, a processing based on consent needs no new consent to be given if it is in line with the conditions set in this regulation. So the final question triggered is knowing whether we all, SMEs, organizations that are non-profit, big companies, get ready on time for the GDPR.